Hello and welcome to the Kenneth for Cameron Law Office Legal Podcast. This edition is preparation for the criminal and municipal court case. And in particular, this is part of the program by the New Jersey State Bar Association and New Jersey Institute for Continuing Legal Education, where attorneys are instructed on how to run a practice like a business and how to better represent their clients. So municipal court typically is a good place where attorneys starting out can get some practice in the skills of dealing with judges, dealing with the courts, dealing with prosecutors. So the phone rings, and that's typically a good ring because it's someone who is in need, potential client. Typically, we never provide advice over the phone. People hear what they want to hear. If someone wants a client, they usually have to get them in. If someone's interested in retaining my law office, they make an appointment, they fill out an interview form, and they come in. Let's say what we do is we email what's called a criminal or municipal court representation appointment email, and it basically says, okay, the appointment is for a specific day, specific time. Please fill out our interview form. Bring with you copies of the tickets, any notices or papers from the court, anything from the police, any police reports, any accident reports, and every paper they have in connection with their case. Someone comes in. Now, what does this questionnaire say? Well, the interview form is not really that complicated. Typically, we want them to provide name, address, their cell phone number, email, who referred them, because we want to send a thank you for a referral letter. What are the charges or the complaints that are issued? We ask them to provide the tickets. And this is in the questionnaire and the email that we sent. Date of offense, the time, the person's age, the street address, where it took place, what happened, and what happened. They can use extra on the back of the page, and that's important. Now, on the next page is also important because it has other background information that any good attorney needs. So, for example, it will say, what are the other people arrested? Who are the witnesses? And question, what did you tell the police? Our questionnaire used to say, did you give any statements to the police? And everyone would say no. But they were thinking of a statement where they were brought to the police station in handcuffs, and they were grilled, and the people said no statements. Well, no. So what did you say to the police? And sometimes people write no, none, or nothing. Everyone says something. No one just zips their lip up and looks at the police officer funny. They may say, I don't want to talk about it. That's good. That's what I want them to put down. We ask the client, what's their occupation? Let's say their employer, how far they work away. Let's say, unfortunately, it's also common if their occupation is unemployed or student. Then I said, well, how can you afford an attorney? We ask them what their prior criminal charges are, prior convictions. That is important, both for American citizens and more important for non-U.S. citizens. So we ask that question now also. Prior criminal charges, sometimes someone says, I don't say, well, who represented you? Why didn't you go back to that person? If they say, well, I was represented by the public defender, I will sometimes ask, well, if you couldn't afford a regular lawyer back then, how you can afford one now? And if they ask about payment plans, I say, well, yes, the payment plan is you put it on your credit card, or you borrow money from your family or friends and you pay them back. Because I'm busy doing my law stuff. I don't have time to be dealing with payment plans. Now, ethics is very important for attorneys. RPC, Rules of Professional Conduct 1.5b, specifically says that there has to be some written statement of fees. So we provide everyone who comes in with a retainer statement. Let's say whether or not it's in municipal court, criminal litigation. Let's say we put down the court. We sometimes, if it's a criminal case, I put down the summons number or like a complaint number, because if they come up with other charges that they didn't tell us about or we don't know about, well, the fee doesn't cover anything else except that complaint. Let's see. The famous Beverly Hills attorney, Jay Foonberg, basically writes the fee, get it up front. And that's the best time to get the fee is when someone really needs an attorney, because someone's not going to get paid later on. Okay, we get my office. We get paid. What? Well, we also go over what we're going to do, and we provide someone. Our retainer statement says what we're going to do for the person. We're going to be available for telephone conferences and office conferences. I do a lot of my calls from my car because I'm running from court to court. We prepare a letter of representation to the prosecutor. We provide copies to the client. So, okay, we've been retained. Um, let's say, and we go over other things with the client. Well, we also remind them that if there's cost or expenses, experts, things like that, that's going to be their responsibility. The law office doesn't pay for experts, and that's the client's decision on whether or not they have the ability or the funds to retain an expert. Now, it is important that the clients cooperate with the attorney. They have to provide the information. They should call our office if their address changes, if their phone number changes. Go into court. We say over and over again, bring everything with you. Bring your papers. I now have a folder that says bring all your papers with you. This way, I'm not if I say take this out, I don't want them to say, well, I didn't know I had to bring it anything. It's just, yeah, bring everything. So, letter of representation to the court goes one to the court, one to the prosecutor, and we also request discovery. Form letter, state versus person's name, date of offense, summons number, what they're charged with. We ask for discovery, and sometimes we'll fax it to the police records if it's a local police ticket. That sometimes will expedite things. What are some pre-trial motions? Well, in drug cases, we will do what's a motion to suppress evidence. We'll do a motion to suppress any statements based upon violation of Miranda. We do a motion to exclude lab tests, and we also make a demand for notes in the operator's manual. I was able to be successful in a recent case because there was 2 kids in the car. There's weed. The police say, well, we want to see the registration, insurance card. Kid opens up the glove compartment. There's weed there. And police claim they smelled weed. Maybe that's true. Maybe not. I filed a motion objecting to the lab tests. The other attorney didn't. Let's see, yeah, it was a 7-month-old case. Let's see, the other attorney was from some office that they send out ticket letters. They do things on the cheap. They don't do stuff right. They didn't do anything. And I said to the judge and the prosecutor, he goes, well, let's see, I'm ready to go right now. I filed my objection to lab tests. So the lab tests don't go against me, but they go against the other guy because he didn't file any lab tests. So judge, you can consider it only against the other guy, and that helped us resolve the case because, let's say, the kid eventually took a conditional discharge, but my client got a dismissal of the drug charges. Other things we do, we make another in the motions. We put in like a discovery shall be provided within X days, otherwise dismissal. It's not going to be dismissed. We advise that reciprocal discovery will be provided after we are provided with all of our discovery. We name some defense experts, and we again make a objection to lab reports, specifically mentioning the statute. Let's see. All right. What can the defense attorney do next? Well, if it's a drug case, there's a conditional discharge if someone doesn't have any priors. I'd say if there's private citizen complaint, we'll sometimes send a letter to the private citizen complainant to see if the case can be resolved without a trial. At least let them know that we want discovery from them. Prosecutor's supposed to provide discovery within 10 days, or at least respond. If there's not a response, sometimes I'll stamp it second request and then send it again. If we don't get a response again, then we do a motion to compel discovery. And sometimes some prosecutors get mad and goes, listen, let's see, my client is not happy, my client is angry, I got to do the best I can. And let's see, preparing for court, I mentioned objection to the lab report, subpoena witnesses, and let's say obtain your discovery, provide that to the client. For in our next edition of this, we're going to discuss other preparation issues for trial. Best of luck to you with your career, and good luck. For other information, visit website njlaws.com or website benotguilty.com. That's benotguilty.com. For other information, call the Law Office of Kenneth Verkaman, 732-572-0500. Thank you, and good luck.